This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why, depending on allegations, there can be no defense of a false advertising claim, and why Kona coffee must be from the big island of Hawaii, or it's not Kona coffee. L&K Coffee claimed its various insurance companies erroneously denied coverage to defend it against a Lanham Act false advertising lawsuit brought by Hawaiian coffee growers. The district court concluded the applicable insurance policies did not obligate a defense and entered summary judgment in the insurance company's favor. In L&K Coffee, LLC versus various insurance companies, including LM Insurance Corporation, the Sixth Circuit resolved the dispute in a decision rendered on June 1 of 2023. L&K Coffee, a Michigan-based company, roasts and sells coffee products throughout the United States. Defendants are insurance companies from whom L&K purchased general commercial liability and umbrella liability policies. Coffee growers from the Kona region of the island of Hawaii sued L&K and other coffee companies for false designation of origin, false advertising, and unfair competition in violation of the Lanham Act in the Western District of Washington. These Kona plaintiffs alleged that the defendants falsely designated the origin of the coffee they branded and distributed as Kona coffee, when most of the coffee beans contained in the coffee product were sourced from other regions of the world. The Kona plaintiffs' operative complaint summarized their contention as to L&K as follows, quote, L&K falsely designated the geographic origin of its Kona coffee products with the prominent placement of Kona in capital letters on the front of the packaging. Close quote. The deceptive marketing was alleged to be designed to mislead consumers into believing that L&K's Magnum Exotics Kona products contain coffee from the Kona district when the coffee products actually do not contain a significant amount of Kona coffee, if any. The plaintiffs also alleged that L&K deliberately misled the consumer into believing that L&K's Magna Exotics coffee products contain significant amounts of premium Kona coffee beans in order to justify the high price L&K charges for what is actually ordinary commodity coffees. L&K asked the insurance companies to defend and indemnify them in that matter under the policy's personal and advertising injury coverage. Personal and advertising injury in pertinent part is defined as an injury arising out of 1, a publication that disparages a person's or organization's goods, products, or services, or 2, infringing upon another's slogan in your advertisement. Based on the language and the Kona plaintiff's allegations, the insurance companies denied coverage because, as one insurer put it, quote, none of the offenses in the definition of personal and advertising injury includes false advertising, and none of the allegations in the complaint fall within any of the offenses in the definition. Analyzing the issues, the Sixth Circuit concluded that the duty of an insurance company to provide a defense depends upon the allegations in the complaint and extends to allegations which even arguably come within the policy's coverage. An insurer's duty to defend does not depend solely upon the terminology used in a plaintiff's pleading. Rather, it is necessary to focus on the basis for the injury and not the nomenclature of the underlying claim in order to determine whether coverage exists. The term disparage means an untrue statement directed towards another's property. A disparagement claim requires a company to make false, derogatory, or disparaging communications about a competitor's product, not to claim that you are selling the competitor's product. The Kona plaintiffs alleged L&K violated the Lanham Act's prohibition on false designation of one's own product. The Sixth Circuit concluded that this is not disparagement. Upon review of the Kona plaintiff's complaint, the Sixth Circuit Court agreed with the District Court that the complaint does not set forth an arguable theory of recovery. In the Kona plaintiff's own words, only coffee grown on farms located within the Kona district of the Big Island of Hawaii can truthfully be marketed, labeled, and sold as Kona coffee. L&K violated the false designation of its product, and that was not a covered cause of loss. In my opinion, it never pays to lie to your customers. When doing so harms someone else, you are subject to damages from those your lie harms. By falsely designating its product as Kona coffee, when L&K claimed its cheap generic coffee was Kona coffee, it was involved in a tort and a violation of the Lanham Act that was not covered by the policies of insurance. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you will be notified daily, usually 5 to 6 times a week, of the new blog postings, and you will have access to the more than 4,500 blog postings. You can also subscribe to these videos on rumble.com, where there's almost 700 videos available, and youtube.com, where there are more videos available, all of which are available free to anyone who subscribes or becomes a follower. And if you found these videos and blog postings to be interesting or useful to you, please tell your friends and colleagues so that they can also subscribe. And if you want more detail, please consider subscribing to my Locals community or my Substack publications. Thank you for your attention.